Joyce, 56 Rick Source, and Honorable Roy G. Meeks presiding.
You may be seated. The case of People versus Robert Presley Jr. Counsel identified for the record.
Chairman Stice, on behalf of the people.
Morning, Your Honor. Gerald White representing Mr. Presley.
All right. And we have Mr. Presley online too, or?
Yes.
Yes, sir.
Okay. And this was just set as a status conference. I see that a new pretrial summary has been offered. And did you receive that, Mr. White?
I have, Your Honor, just received it and went over it abruptly with Mr. Presley this morning.
Okay. Anything else you want to do today, or do you want to set up another status conference 30 days out or something?
Well, there's a lot of options, Your Honor, but here, let me just state what I know at this point in time. At this juncture, right now, we're not accepting the pretrial final offer that's on the board. I want that to be clear on the record. The next thing is I would like to have an opportunity to talk with Mr. Presley breakout wise for another 10 minutes or so if I can. But I wanted to go on record to say we're rejecting the pretrial right now. But as to the status conference, yes, that might be a good idea. And again, I hate to say this for 30 days, but it might give me time to do a little bit more work on this case from Mr. Presley's request, if I can have some additional time with him this morning, and also set up another status conference. Your suggestion of 30 days out sounds reasonable.
Judge, I don't think we need any more status conferences. He's either going to accept the plea or he's not. I haven't received any viable counteroffers from Mr. Presley. He's going to trial. This is my last effort and attempt to resolve the case. He's not interested in resolving that case. Let's just set it for trial.
I think that's a wonderful, Your Honor, I think that's a wonderful idea.
Absolutely.
All right, we'll set it for a final pretrial and a trial date. All
Very
right,
well, Your Honor. Thank you.
okay. And you want another 10 minutes with Mr. Presley before
Yep.
we go on to the other cases?
Yes, please, Your Honor, if you would.
All right, we're in recess.
Thank you.
All right. Meeting presiding.
You may be seated. Calling the case for People versus Joseph Russell Ware. Counsel identify for the record, please.
Chairman Stice, on behalf of the people.
Joe White representing Mr. Ware, Your Honor.
All right, we have Joseph Russell Ware with us.
Yes, sir.
All right. This is a motion to revoke bond. You may proceed, Ms. Ambrositis.
Thank you, Your Honor. I have to find the case. It didn't show up on my list of cases for today. Okay. Okay, Your Honor, we filed a motion to revoke bond. The defendant was not to use alcohol, marijuana, or illegal controlled substances. The court and our office received information that on or about March 28th, the defendant consumed alcohol at a PBT result of a 0.198. And he was charged with a new crime arising out of that particular incident. We would ask the court to revoke bond and establish new bond sufficient for him to comply.
Mr. White, response?
Well, Your Honor, well, number one, my first response is I'm not aware of the new crime allegedly that was issued against Mr. Ware. I do have the motion to revoke bond. I don't have the charge that was pending against him, allegedly pending against him. and I'm aware of that, but I also know that Mr. Ware is scheduled for sentencing because he's entered a plea of guilty in the previous months, Your Honor, and it's been set aside, the sentencing has been set aside till September 13th to allow the prosecution to use him as a witness in another trial. And so I know that if the court revokes bond, he's going to at least be incarcerated under bond, under this revocation till September sometime, mid-September. So I would ask the court to give consideration to extending bond and to put some additional requirements on him relative to the consumption of any drugs or alcohol.
Rebuttal?
Your Honor, the court's going to do what the court's going to do.
Can I say something in my defense?
You want to have a breakout room with your attorney first before you speak?
No, I'm just gonna make the court aware that I've been taking drug tests and these things right from the beginning, and I haven't failed one. It was just one of them deals.
Your Honor, I'm aware that he got into an argument with his brother-in-law, who resides in the same residence with he and his wife. And there was an argument amongst those two over an issue, and that's what led to him consuming alcohol.
All right. Court will do is allow him to remain on bond only if he gets an alcohol tether installed on him by Friday, tomorrow at 4 p.m. And since he's not on probation with the Department of Corrections, he's going to have to get that on a privately done. All right. Otherwise, he's going to have to report to jail by 5 p.m. tomorrow.
You understand that, Mr. Ware?
I'm not sure what that means. I gotta go get a tether put on,
Yes.
or I have to report to jail.
Yes. If you
I
get
have
the tether
to
on,
report to jail.
it's an alcohol tether, so it's going to tell if you're drinking. So we don't want you drinking either. We don't want you doing drugs. We don't want you drinking.
Yes.
All right. So it's an alcohol tether. It doesn't limit you going to work or doing anything. Just limits your ability to drink or be around people who are drinking. They've been known to go off if you go into a bar.
Right. Where do I get this done at?
I think Mr. White can help you out with that.
All right, Your Honor. Yes, I will do that.
All right. And if he fails to get the alcohol tether, bond would be set at $20,000, cash surety 10%. All right.
Very well, Your Honor. Thank you very much.
Mr. Ware, you can hang up now.
Thank you.
In case the people versus Matthew David Johnson.
Good morning, Your Honor. Mark Webb on behalf of the people.
Gerald White, representing Mr. Johnson, Your Honor. Sorry.
Mr. Johnson, you need to turn on your microphone, please.
Mr. Johnson, can you identify yourself, please?
Mr. Johnson, please turn your microphone on.
Mr. Johnson, can you hear us? We can't hear you, Mr. Johnson.
You gotta bring the camera over.
Okay. So, read the sign.
All right, let me try to call Mr. Johnson.
You got it. Mr. Johnson, can you hear the court now? His microphone's on.
Can you identify yourself, Mr. Johnson?
I can finally hear you. Yeah, this is Matthew David Johnson.
All right, okay. This was just set as a status conference. Anything to discuss today, Mr. White?
Yep, yep. Yes, Your Honor. I think the court is aware that this case is the drug case depends upon results of drug testing. And to the best of my knowledge, I have never received a lab report in this matter. I consulted with Mr. Webb yesterday latest, and we still do not have a lab. There's not a lab test available. So in light of that, I would ask the court to give consideration to dismiss the charges in this matter for that lack of evidence presentation to Mr. Johnson, and go from there. If they want to reissue, they can.
Mr. Webb?
Your Honor, I reviewed my notes. I requested that it be sent for testing back in February, and I checked yesterday, and I don't have anything back.
All right. Mr. White, what I'm going to request is that you do a written motion for dismissal in this matter, then based on that, and set it for hearing.
Very well, Your Honor.
All right. You're all set, Mr. Johnson.
Good.
You can hang these now, Mr. Johnson.
Okay.
And I need to like, see if I can find. Yes.
Okay.
Good morning. Can you identify for the court, please?
Good morning. My name's Kevin Myers.
Mr. Myers, you did get your video to work?
Yes, ma'am.
Okay. Thank you. We are going to leave you here and just identify 2 more people, okay?
Yes, ma'am.
Good morning. Can the person with the phone number ending in 167 identify for the court?
Yes, Danielle Giroux.
Thank you, Mr. Rowe. We have not got to your case yet.
Okay,
I'm going to put you back in the waiting room, okay?
okay, thank you.
Thank you. Good
Hello,
morning. Can you identify for the court, please?
Bryant Knapp.
set for 10 o'clock. Back in the waiting.
Mr. Knapp, we're gonna put you back in the waiting room until we call your case, okay?
Okay, thank you.
Thank you. I don't mean just.
All right, we have the prosecutor. Calling the case of the people versus Jessica Renee Connor. Counsel identify for the record, please.
Joe Embers, appearing on behalf of the people.
Joe White on behalf of Mr., excuse me, Ms. Connor.
And we don't have Ms. Connor on Zoom. She's not here in court. This was set as a restitution hearing. And do you expect her to Zoom in today, Mr. White?
I thought, Your Honor, I sent to her a communication to the effect of the hearing. I had talked with her. I'm not sure her whereabouts at the present time, so I'm not sure if she wants to pursue the restitution hearing.
All right, well, we're gonna continue without her, I guess, since she's knew the date and time that it was supposed to happen. So, Ms. Ambrositis, you may proceed.
Thank you, Your Honor. Call Kevin Myers.
Yes,
Mr.
ma'am.
Myers, would you raise your right hand and be sworn, Mr. Myers?
Yes, sir.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Kevin, could you please state your name and spell it for the record?
Kevin Myers, KevinMeyers.
Thank you. Kevin, you were dating or had a Jessica Connor stay at your house?
Last or 2019, yes.
Okay. And at that time, did she do damage to your items or certain items at your house?
No, ma'am. It was done after we had broken up for a couple months, and I had went to Walmart to go buy groceries, and 20 minutes later, after I got home, she showed up at my house.
Okay. So forgive me for being ineloquent about how I did that. She did some damage to your property, correct?
Yes, ma'am.
And she was charged and has been sentenced on that, correct?
Yes, ma'am.
And you have asked for $8,594.51 in restitution. Is that also correct?
I believe that's the total. I turned in receipts, and I don't know exactly what the total was, but
Okay, what items specifically were destroyed?
oh God, I don't have it. I believe it was 7 wall mount fans. I believe. I don't know for sure the number. Like I said, it was turned in, and then 2 dehumidifiers. My front door was broken out, so I had to replace that. And then the marijuana. I believe
Okay.
that was what was turned in.
So you said the fans, how much did those cost you?
I turned in the receipts. Are you still there?
I'm still here.
All right. I'm sorry. I'm not really good with my phone, so I got to go into my gallery to look at my receipts. They were $58.28 before taxes.
Okay, and then you said you had some wall-mounted lights?
No, ma'am. It was just the wall-mounted fans and the dehumidifiers.
So the wall-mounted fans, was that the 58?
Yes, they're $58 a piece. I purchased them on June 10th of 2020.
And then the humidifiers, how much were they?
Dehumidifiers were $849.99, before tax. And there was 2 of them. And I purchased them on June 1st of 2020.
And these are items that you utilized in the growing of marijuana?
Yes, ma'am.
And this is medical marijuana?
No, for me, it wasn't medical. I could have got it as medical, but I'm a disabled vet on a fixed income. So I kind of figured since it was legal in the state and it was, you know what I'm saying? All I was doing is paying more money for my medical license. 'Cause I'm a disabled vet with lots of medical
I
issues.
understand. So it was recreational marijuana, is that correct?
I guess as far as labeling, yes, it was medical for me, but it was, I guess, under the,
I need the correct term for it. So you didn't have a medical marijuana license. This was recreational marijuana, is that correct?
yes, ma'am.
Okay. Are you a caregiver for anybody?
Yes, ma'am.
And how many people are you caregivers for?
Just one. But I wasn't growing for her. I was only growing 12 plants.
So those 12 plants were for your own personal consumption?
Yes.
And they were recreational, not medical?
Yes, yes, ma'am.
How much did you have to pay to get your door fixed?
Seat on that one is $487, I believe, is what the receipt said. In 80s, $480.87, I believe.
Okay, so we have $480.87 for the door. And tell me again what you said you paid for the fans?
It was $58.28 before taxes. I don't
And
have
how
the
much did
tax
you pay for the humidifiers?
$849.99 each, and there was 2 of them.
Was anything else damaged?
Yeah, a couple of my fences, my privacy fences got damaged, but I didn't know how to price that or how to.
Did you
I don't
fix
know.
it?
I haven't fixed it yet, no.
So they are still serviceable?
Yeah, but not very aesthetic, I guess.
Anything else damaged?
No, I believe that was it. She knocked some cameras off and broke the mounts on them, but the cameras still work.
Okay. No further questions, Your Honor.
Mr. White?
No questions, Your Honor.
And so, Mr. Myers, you're asking for reimbursement for the marijuana plants, is that correct?
Yes, sir.
I would object to that, the recreational marijuana value.
Your Honor, I would agree. That's why I didn't continue to follow that line of, it was always been my understanding he was a medical marijuana card owner, and she destroyed his medical marijuana plants along with his plants for the individuals he cared for, but clearly that's not the case based on his testimony today. So we would be asking for the court to order restitution amount $2,239.13 to cover the other items that he did testify to today that were destroyed or damaged.
All right, and that was without taxes, so we'll add 6% for taxes to that amount, and that'll be the award.
I'll do the math really quick, Your Honor, and let you know what that is.
The court will sign an order upon presentation.
Thank you, Your Honor.
Your Honor, I have
So-
to, you have Mr. Webb on the next case. I have IT here to deal with an issue with my computer, so I'll be back on in a moment.
All right. You're all set, Mr. Myers. You can sign off.
Mr. Myers, you can hang up.
I'm working on it.
Okay.
Does that complete my,
Yeah, that completes your cases, Mr. White.
thank you very much.
Thank you.
Have a good day. Thank you.
I have Frank Province on the docket.
Oh.
I don't know if you need to be around for that or not.
Mr. Province was taken off the docket. He's being an internal reassignment to Judge Evans.
Oh, okay, thank you.
All right, thank
Yep.
you.
All right. Calling the case of the people versus Danielle Nicole Giroux.
Yes.
Good morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Ms. Giroux.
You are Danielle Nicole Giroux?
Yes, I am.
All right. This appears to be set as a pretrial. Has a pretrial summary been filled out, Mr. Webb?
I thought it had, Your Honor. Maybe I missed it.
I've received a copy from Mr. Webb, Your Honor.
All right.
You did?
The court doesn't have a copy, not in the file anyways. So-
I'll get one to you today, Your Honor. My apologies.
Okay.
I'm sorry, that would be the probable cause conference summary. I was confused on that.
Oh, okay.
It's the same offer as that, I believe. Austin, I did find her CCH yesterday and she does not have any priors, so it's still the same offer.
Your Honor, Ms. Giroux would like to accept the plea bargain offer.
And what is the offer?
Your Honor,
Your Honor, I'm sorry. Go ahead, Mr. Webb.
he can plead guilty to count 1, possession of methamphetamine. I'll dismiss count 2 at sentencing and recommend no initial incarceration.
And then, Mr. Rowe, is she gonna apply for 7411 status? Is that it?
Yes, Your Honor, if she's eligible.
Okay. Ms. Drow, did you hear that?
Yes, I did.
All right, and you're in agreement with it?
Yes.
Would you raise your right hand and be sworn?
Yes.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And Ms. Drow, you received a copy of the information or had a discussion with Mr. Rowe about those charges, is that correct?
Yes, I did.
And Mr. Rowe, is your client waiving the reading of the information?
She waives the reading, Your Honor.
And she previously waived preliminary examination, is that correct?
That's correct, Your Honor.
Ms. Drow, you're being charged with count 1, controlled substance possession of methamphetamine. That's a felony. It carries a maximum penalty of 10 years in prison and or a $15,000 fine. And the information states that you could, unless sentenced to 1 year in prison, the court shall impose license sanctions. Although there's some new laws regarding license sanctions, and I don't know if they've taken effect at this point yet. Those are the maximum penalties. The minimum is discretionary with the court. Do you understand the charge and the possible penalties, Ms. Drow?
Yes, I do.
There's one of 3 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make?
Yes.
Answering to count one, controlled substance possession of methamphetamine, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be?
Yes.
Court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes.
You understand by pleading guilty, you give up each and every one of those rights.
Yes.
Mr. Webb, would you state the plea offer on the record again?
Sure, Your Honor. In exchange for the defendant's plea of guilty to count one, possession of methamphetamine, I will dismiss count two at sentencing and recommend no initial incarceration. And it's my understanding she's going to apply for 7411.
Mr. Rowe, is that your full complete understanding of the plea agreement?
It is,
Yes.
Your Honor.
Mr. Rowe, did you hear what was put on the record as the plea agreement?
Yes.
Did you understand it?
Yes.
And are you in agreement with it?
Yes.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
I do not.
Have you understood everything that the court has told you?
Yes, I do.
In light of everything the court has told you, do you still wish to plead guilty?
Yes, sir.
Drawing your attention to on or about February 17th of 2021, were you in Hayes Township, Clare County, Michigan?
Yes, I was.
And did you have in your possession some methamphetamine?
Yes, I did.
And you knew it was methamphetamine?
Yes, I did.
Did you have any license or prescription to have that in your possession?
No, I did not.
Satisfied with the factual basis, Mr. Webb?
Yes, Your Honor.
Satisfied with the factual basis, Mr. Rowe?
Yes, Your Honor.
Does the court comply with the court rules, Mr. Webb?
You have, Your Honor.
Does the court comply with the court rules, Mr. Rowe?
It has, Your Honor.
Court has not agreed on possible plea or the possible sentence with either the prosecutor or defendant or anyone acting in the interest of either. Plea is accepted in order to enter upon the records of this court. Sentencing will be set for June 14th. At 10 a.m. or 10:20 a.m. Defendant is referred to the Department of Corrections to the preparation of a pre-sentence investigation report. Bond is continued. Mr. Ween, any questions or information for Mr. Rowe?
Mr. Rowe, could you please verify your address for the court?
511 South Clemens Avenue, Lansing, Michigan.
Was that South Clemens Avenue?
Yes.
It's in Lansing?
Yep.
What is the zip code down there?
48912.
Could you please verify your telephone number, please?
517-231-2167.
Rowe, we're going to be sending you some packets in the mail. You need to complete those upon receiving them and then call the agent that is listed on the cover sheet.
Okay,
All right, thank you.
thank you.
You're all set, Mr. Rowe. You can sign off.
Thank you.
Calling the case of the People versus Caleb Lee Keeler.
Sure, besides bringing back people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Keeler.
You are Caleb Lee Keeler.
Yes, sir.
It says a pretrial summary has been provided to the court. Mr. Rowe, have you received a copy of that pretrial summary?
I have, Your Honor.
And does your client wish to take advantage of the offer today?
Mr. Keeler, do you want to plead guilty according to the offer today, or would you want to proceed to trial?
I'd like to proceed to trial.
Your Honor, I'd note that Mr. Keeler and I have discussions about that. Mr. Keeler is still open to negotiation, but at this time, he does not accept the offer.
All right, this will be set on the trial docket with a final pretrial and a trial date being set. Anything else to discuss, Mr. Rowe?
No, Your Honor.
All right, you're all set, Mr. Keeler. You can sign off. On the case of the People versus Michael David Archibald.
Sure, besides bringing back the people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Archibald.
And Mr. Archibald's not in the courtroom, and apparently we don't have him on Zoom. Have you had contact recently with Mr. Archibald, Mr. Rowe?
Your Honor, I attempted to call him yesterday. I was only able to get his father. His father told me that Mr. Archibald is on the way to a detox facility in Hillsdale. He didn't know which detox facility that was, or his address or phone number. I've not had contact with Mr. Archibald.
Are you going to make some investigation to try and find out which facility he's in?
Your Honor, I'll try to call the father again, but he was not very, he first answered the phone and said, "I don't know you," and then he was not very cooperative, so I can try again.
All right, what we're gonna do, if he's in a detox facility, those don't last very long, but if he's in an inpatient, that's a little different. So what we'll do is we'll adjourn this pretrial and send out a notice for a new pretrial date. That'll give you an opportunity to investigate, try and find out where he's at. All right?
All right.
And if you can't find him, use an investigator. All right?
Good morning. Can you identify for the court? Melissa? Melissa, can you identify for the court?
I'm sorry, I just fixed the sound. What was that?
Can you identify for the court, please?
I am who I am, Melissa Kuzina with Craig's Bail Bonds.
In what case?
The case number is 19006-095.
The name of the defendant?
Wesley Lentz.
Melissa, he's not on our docket today.
Okay, yeah, the person who normally handles the show causes is tied up in another one, so she asked me to join this meeting. So I'm not 100% sure.
Would it be in
She told
district
me it was
court maybe?
20.
What's the case number again?
It looks like 190060955FH.
All right. Can we look that up on our computer?
Review. What was that, 19?
Do a motion to revoke bond. We all very issue a bench warrant. Mr. Webb or Ms. Ambrositis, do you know anything about Wesley Clements, a motion to revoke bond?
I don't.
Can you provide me with the case number again? It was 19.
0695, 6095, sorry.
And is that FH or FC?
FH.
FH. Looks like we have a circuit court show cause on 4/30 of 2021
Okay.
at 10:30. So I think you're a week early.
Okay, hang on.
It
Let me write
looks
down
like
the new
it,
date because this one doesn't have it right.
yeah, it looks like it was scheduled for looks like we had 3 dates. It was scheduled for the 22nd, and then it was moved to the 26th, and then it was moved to the 30th. There was a lot of shuffling of cases for docket overage. And so there was a lot of rescheduling, but it
Okay,
looks like
so-
you're 4:30 at 10:30 in the morning.
At 10:30. Okay, it's the same case number?
Yeah, it's Wesley
Case
Lentz.
number,
Yeah.
okay. Okay, all right, thank you very much.
You are welcome.
Yep. On the case of the people versus Kenneth Joseph Young, counsel identify for the record, please.
Schumer Zayas, appearing on behalf of the people.
Your Honor, Austin R. Rowe on behalf of Mr. Young.
And we don't have Mr. Young present in the courtroom or by Zoom. The pretrial summary was submitted to the court. Mr. Rowe, have you received that pretrial summary?
I have, Your Honor.
All right. And have you had any contact since you received that with Mr. Young?
Well, Your Honor, I do not understand why he's not present or on Zoom today. I talked with him yesterday about this hearing.
Good morning. Can you identify for the court, please, the person on the phone?
Bryant Knapp.
Okay, Mr. Knapp, we haven't got to your case yet. I'll put you back in the waiting room.
Yes, ma'am.
How do you wish to proceed today on this?
Yes, for a bench warrant, Your Honor.
Your Honor, I'd ask if this could be adjourned because, like I said, I talked to him yesterday on the phone to remind him of today's hearing. I don't know why he didn't show up. I don't know if he's got some technical issues, Your Honor.
Ms. Ambrositis, is somebody from your office available tomorrow morning if I withhold the bench warrant until tomorrow at 10 o'clock?
We may have an attorney here tomorrow available. I can't guarantee it. Short notice.
All right. Well, the court's going to give Mr. Young until 10 o'clock tomorrow to appear. If he fails to appear, his bond will be canceled. The bench warrant will issue for his arrest. Bond in the amount of $100,000 cash. And there will be a forfeiture of the bond. So we'll set a forfeiture hearing, but we'll give them until 10 o'clock tomorrow morning to show up, Mr. Rowe.
Thank you, Your Honor.
On the case of the People versus Charles William Doherty.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Doherty.
You are Charles William Doherty.
Can you unmute your microphone, Mr. Doherty? There you go.
Yes, Your Honor, I am.
Mr. Doherty is currently on probation for controlled substance possession of analogs. A felony carries a maximum penalty of 2 years in prison. A 2-count violation was filed against him. How do you wish to proceed today, Mr. Rowe?
Mr. Doherty, I have communications with Mr. McConnell since we last talked this morning. He's not changed his position. It'd be the same offer. You want to accept that offer?
Yes.
Your Honor, Mr. Doherty would like to accept a plea bargain offer in which he pleads guilty to, I believe it's count 2, and that the recommendation would be 6 months jail with credit for 62 days served, and that he'd continue on for probation with an extension of 1 year on probation, and that the probation office would have no objection to Mr. Doherty receiving day-for-day credit for rehab that he successfully completes.
All right. How old are you, Mr. Doherty?
49, Your Honor.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Count 2 is violation of Rule 29, Special Condition 4.25. There's one of 3 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stay on mute, in which event the court will enter a plea of not guilty for you. You understand that one of 3 possible pleas you may make?
Yes, Your Honor.
Answering the count 2 violation of Rule 29, Special Condition 4.25, how do you plead?
Guilty.
You understand that if your plea is accepted, you will not have a hearing of any kind and therefore give up the following rights: the right to a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney if you're unable to afford one. We have appointed Mr. Rowe to represent you. That the maximum possible sentence could be 2 years in prison. The minimum is discretionary with the court. That you give up the right to appear at a hearing, present evidence, and cross-examine witnesses. You give up the right to have the prosecution or probation office establish a violation by a preponderance of the evidence. Give up the right to remain silent and not have that silence used against you during the hearing. And you give up the right to testify at the hearing if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
I do, Your Honor.
Do you understand by pleading guilty, you give up each and every one of those rights?
I do, Your Honor.
Has anyone promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, Your Honor.
Has anybody threatened you or your family in order to induce you to plead guilty?
No.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead guilty?
Yes.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No.
Have you understood everything that the court has told you?
Yes, I have. Yes, I do.
In light of everything the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
And part of your probation was to report any change of residence to the field agent within 24 hours, weekends and holidays accepted. Is that correct?
Yes.
And is it true you changed your approved residence?
Yes.
And you failed to contact a field agent within 24 hours of that move, excluding weekends and holidays. Is that correct?
Unfortunately, Your Honor, yes.
All right. Court finds a factual basis for the plea. Has the court complied with court rules, Mr. Rowe?
It has, Your Honor.
Court is satisfied the plea is understandably, voluntarily, and knowingly made. The plea is accepted and ordered entered upon the records of this court. Do you wish to go to sentencing today, Mr. Rowe?
Yes, Your Honor.
All right. Your client's waiving the right to have an updated case report in this matter. Is that correct?
That's correct, Your Honor.
All right. Mr. Daugherty, is there anything you wish to say to the court before the court passes sentence?
Your Honor, I just want to say that I feel I'm a good person. I'm an honest person. I've tried to comply with what the courts has asked me to comply with. I went through a very bad personal experience, 14-year breakup with my partner, and I wasn't thinking correctly. I asked the court to be a little lenient on that. But yeah, I am guilty of not reporting my residence and not verifying that I had already done my 40 hours of community service work. But I had already done it, but there is no proof of that.
Mr. Rowe, on behalf of your client?
Your Honor, Mr. Daugherty asked the court to render the sentence according to what the plea bargain was. Mr. Daugherty has explained to me that when he lost his housing, apparently from the way he described it to me, I understand it that he was going from place to place, and he figured that the probation officer wouldn't approve where he was at while he was trying to obtain residences, Your Honor. So it's I think Mr. Daugherty has learned from this experience. I think that if this occurs again, I think he'll most likely to call the probation officer and hopefully maybe even ask him for help finding residence if he's having problems finding that, Your Honor.
In order to punish the defendant for what he's done, the attempts to rehabilitate him, deter others from committing similar acts of protection of the community, be the sentence of this court that he be continued on probation, that it be extended for 1 year with all those original terms, that he be sentenced to 6 months in the county jail with credit for 62 days served. The court will allow him to go into an inpatient program and get day-for-day credit. And the court will allow him to go into the inpatient program immediately if he's available to get into one. If the program is less than the length of the sentence, then the court would suspend the rest of that sentence. How much are you charging for attorney fees, Mr. Rowe?
Your Honor, I estimate about 150.
Court will assess him another $150 in court-appointed attorney fees.
Your Honor, may I ask a question?
You may.
I missed, how much jail is he to serve? I'm sorry.
6 months, but the court is allowing them to immediately go into an inpatient treatment program. So if they can get in, he can go in. And if that's shorter than the rest of the time that he needs to serve, then the court will suspend that jail time if he successfully completes that inpatient program.
All right, thank you.
All right.
Your
You're
Honor,
entitled to it. Yes,
I apologize. Just looking in the PV report, I believe the jail credit is incorrect at 62 days.
all right. What do you think it is?
93.
All right, court will give him 93 days credit. Mr. Doherty, you're entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court would appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate's rights form when it's given to you. Bond is canceled. The case is adjourned. You're all set, Mr. Doherty.
Thank you, Your Honor.
Your Honor,
Yes.
on a separate matter with regards to Mr. Young, we're attempting to make contact with him at this time to see if he can call in.
Okay.
And according to Agent McConnell, who's speaking with him currently, he's trying to get on Zoom right now for the hearing.
All right. Calling the case of the people versus John David Davies.
Good morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Davies.
You are John David Davies?
Yes, Your Honor.
Previously, you appeared in court and you pled to the charge of controlled substance possession of narcotic, cocaine less than 25 grams. That's a felony, carries a maximum penalty of 4 years in prison. Minimum is discretionary with the court. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 11 months. Mr. Rowe, have you had the opportunity to review that pre-sentence investigation report with your client?
Yes, I have, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert in that report?
No, Your Honor.
Any objection to the scoring of the guidelines?
No, Your Honor.
Mr. Webb, on behalf of the people?
Thank you, Your Honor. I've reviewed the report. I have no additions or corrections to make to it. And I also agree that the guidelines are correctly scored.
Mr. Davies, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor, just that I worked really hard to truly learn from this and grow and have this better my life and learn from this. So I've worked really hard. I have.
Mr. Rowe, on behalf of your client?
Your Honor, I would just kind of elaborate that Mr. Davies has worked hard. He's gone through a rehab program. At one point, he was hired into Bear River recovery facilities to work with them. They were impressed at his, I believe, recovery and his skill. He tells me right now he's temporarily laid off for I believe a health issue and a license issue, but Your Honor, he I believe he still has that job. He's shown exceptional progress. I think the incident that comes before the court today is because of a relapse. I think Mr. Davies is sincere when he says he's learned from that. He's gotten back into recovery and rehabilitation process. I believe he understands he needs to do this probably for life to keep from relapsing again, Your Honor. ask the court to honor the plea agreement and to sentence accordingly.
Mr. Webb, on behalf of the people?
Your Honor, I'd just ask you to follow the plea agreement and the recommendation from the probation department.
Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 0 to 11 months. In order to punish you for what you have done, to attempt to rehabilitate you, to deter others from committing similar acts in protection of the community, be the sentence of this court that you be placed on probation for a period of 1 year, 6 months, along with the statutory terms of probation as the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must attend AA, NA, or CA meetings at the frequency required by the field agent. You must complete outpatient residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service as directed by the field agent. If you successfully complete that 100 hours, the court will suspend $700 of your fines and costs. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must be in your approved residence between the hours of 10 p.m. and 5 a.m. unless excused by first obtaining written permission from the field agent. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You must comply with DNA testing, pay a $60 fee, pay a $68 state cost, pay a crime victims assessment of $130, pay a supervision fee of $30 a month. Court costs of $500 a fine and $500. How much are you charging for attorney fees, Mr. Rowe?
Your Honor, I think in this case, it's about $800.
$800 in court-appointed attorney fees. Probation officers of this court and any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, and confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. You're entitled to an appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate rights form and return it when you receive it. Mr. Ween, any information or questions for Mr. Davies?
Mr. Davies, can you take down this telephone number, please?
I sure can.
989.
Okay.
329.
Okay.
9820.
Okay.
You're going to contact Agent McConnell, who I believe is going to be your probation agent.
Do you want me to call him today?
Yes, do that before 3 PM, please.
Will do. Yes,
Thank
sir.
you.
Yep, thank you, sir. Before 3. 4, 3 minutes, 10:36 right now, so we got time. Okay, so we got 4, 3. I'm gonna write that down on a, write that down on a piece of paper. So Agent McConnell.
You're all set. You can sign off, Mr. Davies.
All right, God bless. Thank you, everybody. Thank you.
On the case of People versus Kenneth Joseph Young.
John Resides, appearing on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Young.
And you are Kenneth Joseph Young?
Yes, sir.
This was set as a pretrial. A pretrial summary has been submitted to the court. Court is signing the pretrial summary. Mr. Rowe, have you had an opportunity to go over the pretrial summary with your client?
I have, Your Honor.
How do you wish to proceed today?
Your Honor, Mr. Young would like to proceed to trial. He's still open to negotiations.
All right. This will be set on a trial docket with a final pretrial being scheduled next and a trial date. You're all set, Mr. Young. You can sign off.
Thank you, sir.
On the case of People versus Brian Laurel Webb.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Webb.
John Resides, appearing on behalf of the people.
You are Brian Laurel Webb?
Sir.
Previously, you appeared in court. Pled to the charge of police officer assaulting or resisting or obstructing. That's a felony, carries a maximum penalty of 2 years in prison. The minimum is discretionary of the court. He also pled to the charge of breaking and entering illegal entry, a misdemeanor that carries a maximum penalty of 90 days or 93 days in jail. A pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 9 months. Mr. Rowe, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert in that report?
Your Honor, I have a concern about the credits. Now, the jail credit is currently at 73 days. My understanding was that when Mr. Webb was entered his plea, that he was to have a personal recognizance bond and be released from the Clare County Jail after he'd had a PSI interview with Probation Officer Ween. And that was back on February 22nd. Now, Mr. Webb is, he had another case going in which he was sentenced in district court in, I believe it was March. If I may check this real quick, Your Honor, be accurate. Around March 15th, he tells me that he was given time served, but to my surprise, I found him in the Clare County Jail, Your Honor. So,
Court record does state that he was supposed to be given a PR bond after his PSI sentence interview. So it's unfortunate that that did not occur. So the credit would be substantially more than the 73 days at this point.
Your Honor, I can look into the jail credit. I did not do the PSI. Agent Medley did on this case.
All right.
We'll have to look into that, Your Honor.
And the report gives jail credit to March 3rd. It's now April 22nd. So we're really looking at another 50 days of credit. It's unfortunate. So it should be about 123 or so. My apologies, Mr. Webb, but nobody brought it to my attention.
That's okay, Your Honor.
Anything else, Mr. Rowe, regarding the factual natures of the report?
No, Your Honor, I discussed the report with Mr. Webb and he found it factually accurate.
No objection to the scoring of the guidelines?
No, Your Honor.
Ms. Ambrositis, on behalf of the people?
Your Honor, we've had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate. We've also reviewed the prior record variable score and the offense variable scoring and find that to be accurate as well.
Mr. Webb, is there anything you wish to say to the court before the court passes sentence?
No, sir. No, Your Honor.
Mr. Rowe, on behalf of your client? Your Honor, Mr. Webb asked the court to honor the terms of the plea bargain. Your Honor, it appears that really Mr. Webb is new to the criminal justice system. Your Honor, this is besides what had occurred, and this is one of two criminal events. One occurred in district court concerning OWI. Your Honor, I ask the court to take that in consideration when rendering the judgment also.
Ms. Ambrositis, on behalf of the people?
We ask that you follow the plea agreement and the recommendations.
Court has reviewed through the pre-sentence investigation report that does provide for sentencing guidelines of 0 to 9 months. I do find this was an agreement for a delayed sentence. Is that correct?
That's correct, Your Honor.
Do you find he's appropriate candidate for a delayed sentence in this matter? In order to punish you for what you have done to attempts to rehabilitate you, deter others from committing similar acts of protection of the community, the sentence of this court that you be placed on a delayed sentence of 1 year, along with the statutory terms of a delayed sentence probation. You're going to have the following special terms. You must not use or possess alcoholic beverages or other intoxicants or enter any place that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must attend AA, NA, or CA meetings at the frequency required by the field agent. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service as directed by the field agent. If you successfully complete that 100 hours, the court will reduce your fines and costs by $600. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must comply with the Michigan Department of Correctional electronic monitoring program when referred by the field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must not have any verbal, written, electronic, or physical contact with Hunter Whitaker, Tucker Weaver, Bradley Slack, or Cheyenne Photo, either directly or through another person. You must comply with DNA testing and pay a $60 fee, pay us $118 in state costs, pay crime victims assessment of $130, court costs of $500, a fine of $400. How much are you charging for attorney fees?
Estimate of $500, Your Honor.
And $500 in court-appointed attorney fees. Probation officer of this court or any other supervising agent may pursuant to MCL 771.4 apprehend, detain, and confine a probationer who is in violation of a probation condition or who is conducting himself inconsistent with the public good. You must not use or possess recreation or otherwise possess, purchase recreational marijuana or be in the home or company of anyone who uses or possesses recreational marijuana. You must not possess, purchase, attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days. You must pay restitution to all victims if ordered. There's no restitution ordered. You must pay a supervision fee to the state of Michigan, the amount of $30 a month. And if they put you on electronic monitoring, then it would be $60 a month. You do everything you're told, Mr. Webb, good things happen. You will not have a felony record. If you failed to follow all the rules, then you're going to come back in front of this court for sentencing again. So make sure you comply with all the rules. Mr. Wing, any questions? Any questions for Mr. Webb? Or any information?
Mr. Webb, I'm going to provide you with a telephone number. Do you have a pen?
Yes, sir.
Okay. You're going to be contacting Agent Medley upon your release. Her number is 989-598-5945.
All right.
Thank you.
Good luck to you, Mr. Webb.
Thank you, Your Honor.
So in the case of the People versus Bryant, Allen Knapp.
Morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Knapp.
Mr. Knapp, are you still with us? Can you hear us, Mr. Knapp? If so, unmute.
I can hear you. I'm sorry.
All right.
I was having a problem with getting my phone to unmute.
Okay. We can hear you now. Well, this is set up as a status conference. Any news or anything further that we need to discuss on this matter, Mr. Rowe?
Your Honor, after discussions with Mr. Knapp yesterday, I believe he wants to move to have me removed as his court-appointed attorney and another one substituted in. Is that true, Mr. Knapp?
Yes.
All right. What's the reason, Mr. Knapp?
Because I don't trust that he's doing his job with my best interest at hand.
Well, is there some motion or something that you wanted him to file that he failed to file?
He hasn't really talked with the prosecutor about anything that I'm trying to do here. I'm trying to get myself help instead of just sitting my time in jail. I would like to do some sort of rehab or something. I mean, I understand that I'm probably still going to have to do some jail time, but in lieu of some of that jail time, I would like to do something with rehab. I posted bond on Sunday, and since then I have been in contact with a couple of different rehabs trying to get myself a bed set up.
Anything further, Mr. Rowe?
No, Your Honor.
So, Mr. Knapp, you think you can work better with a different attorney, is that correct?
Yes,
You think there's been a breakdown in the communications with Mr. Rowe?
yes.
All right, the court will allow Mr. Rowe to withdraw and appoint the next attorney on the list to represent you. We will set this for a status conference 30 days out or so. Let's see. We'll appoint you, Karen Tomchuk. We'll set a status conference for May 24th at 10 a.m. So give Ms. Tomchuk 3 or 4 days before you contact her so that we get her notified that she's representing you, okay?
Okay.
All right. And we'll be back on the 24th to see what else has occurred, all right?
All right.
You're all set, Mr. Knapp. You can sign off.
Thank you.
Your Honor, I believe that concludes my cases before the court this morning.
I believe so. You're all set.
Have a good day, sir.
All right. We're in recess.
All right. All right. 55th Circuit Court is now in session. Honorable Roy G. Meek presiding.
You may be seated. Calling the case of Laura Maselli versus Jose Miller and Catnut Pallet Inc., doing business as Northern Pallet. Counsel, identify for the record, please.
Good afternoon, Your Honor. May it please the court, Eric Miles on behalf of the plaintiff.
You're muted, Mr. Klaus.
Okay. Now you're in. Can you hear me now?
Yes.
JJ Klaus representing the defendant in this matter.
All right. Are any of the parties attending via Zoom too, or anybody know?
I have Mr. Miller here with me today.
Okay. All right. Well, the court heard a motion for summary disposition by the defendants regarding C8 and C10. Court has read both the motion in brief and the response in brief. And court feels that the law and argument as discussed in the plaintiff's response is more correct for the situation and is going to deny the motion for summary disposition. And it's clear that both parties sort of state the facts. Their interpretation as to the law is different. And I think the plaintiff's response interpretation is more, it really is an issue of some facts and how a jury, the finder of fact, is going to look at those facts and decide what they mean. So the court is going to deny the motions for summary disposition. The court will sign an order upon presentation, and plaintiff's attorney is to draft the order.
I will, Your Honor. Thank you.
Anything else?
Yeah, Judge, what are we doing about jury trials at the present? Are we gonna have this jury trial in June?
We're scheduled for a jury trial in June, but there's no way we're gonna be able to have one in June. In fact, I just told them not to call in jurors for June because we're back to phase 1. I have no idea when we're gonna get into phase 2. If we get into phase 2, we can have a jury trial, but the way COVID, well, the way we have to look at the number of cases and the trends, it's just not in the foreseeable future right now that we're going to have a jury trial. So what the court will do is we'll adjourn those next 2 dates. I think we have a settlement conference and a jury trial scheduled for June. what we'll do is we'll set a status conference for June and then settlement conference and then a jury trial date after that. All right.
Okay.
Anything else?
Nothing further from me, Your Honor.
All right.
Thank you.
Thank you.
Thank you.
Find the case, Jeff Burgett versus Robbie Richardson and Jeff Burgett versus Nicole Richardson. Counsel identify for the record. Please come up to the tables.
And please, the court, Scott Moore for the respondent.
Robbie Richardson. State your name.
Nicole Richardson.
Jeff Burgett.
All right. Court held a hearing on an order to show cause. Standard of proof is beyond a reasonable doubt. As to Jeff Burgett versus Nicole Richardson, the court does not find beyond a reasonable doubt that she violated the personal protection order. But in the case of Jeff Burgett versus Robbie Richardson, I think the video was very telling, and it does show that there was contact in violation of the personal protection order, and finds him guilty of violating the personal protection order. Mr. Moore, did you want to go to sentencing today, or would you like to have a sentencing date set out?
Correct, my client. We're ready to proceed, Your Honor.
All right. Mr. Burgett, is there anything, or Mr. Richardson, is there anything you wish to say before the court passes sentence?
No, sir, besides I've made it clear to all my neighbors that I don't want this problem with them. I've been trying to end it. There's been no further contact with him since. My other neighbors have had to call the cops on this same, him trying to hit people in the same exact spot I was at since. There's been several reports. I have not had any issues with him. I'm trying to ignore him, leave him alone. We started our own business and I can't deal with this. I have heart problems right at the minute and this is just making it worse. I just want to be left alone by him. That's it.
Mr. Moore, on behalf of the client?
Thank you, Your Honor. I will note that there was a related felony matter that was dismissed by the people. While that in itself doesn't have much legal significance, I think it does suggest to the court that they felt that this matter had been resolved to some extent and that the case was being kept between the parties. This hearing was from October, the violation months before that. The fact that there have been no further violations, I think we should initiate against a jail sentence of any kind. I think the parties have figured out what's going on and what the boundaries truly are. I believe that a monetary sanction alone would be sufficient. Thank you.
Mr. Burgett, any comments before sentencing?
No.
The past 6 months does sort of show that there has been no other problems, and hopefully that the parties understand what the situation is and are going to abide by the personal protection orders. So the court is going to assess $100 in court cost to Mr. Richardson, a $50 fine, and how much are you charging for attorney fees?
This is not actual cost, but I recognize that there was a significant overlap between this case and the felony.
I understand that too.
There was a dismissal which could not be filled. The The hearing itself took 2 hours, so that's $200. I'd be satisfied with that.
All right. Court will assess $200 for appointed attorney fees. Court's also going to order Mr. Richardson to do 40 hours of community service. And, if you successfully complete the 40 hours of community service, the court will abate the fine and cost.
Can I say one more
I
thing?
really would, I think that's, the court has ruled.
It's
On
not
this
about-
record.
I know, but it's not about
If I could
this.
concur with my client.
Yeah, so probably a good idea.
Okay. Your Honor, I'm just going to state this, and I'm not saying anybody's taking a position. If Mr. Burgett is of a mind to terminate the PPO, he certainly may do so. We're not asking for that, but if that's his desire, we get the forms of the court on top. Okay, thank you.
All right.
Thank you, Your Honor.
We're in recess. Thank you.
All right. All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. In the case of Laura Marie Maselli versus Michael Stephen Summers, counsel identify for the record, please.
Good afternoon, Your Honor. Joseph Duso on behalf of the defendant, Michael Summers.
Good afternoon. I'm Laura Maselli representing myself.
All right. And you are Michael Summers?
I'm sorry, I didn't hear you.
Please, Mr. Summers, you have to unmute.
Yes, Michael Summers.
All right. And this was just set for a status conference on the request of the defendant. Mr. Duso, what did you want to discuss?
Thank you, Your Honor. I had prepared an order after hearing, and the only issue that came up, I guess that I'm kind of trying to get clarity from the bench, is at the end of the oral opinion, I asked the court in regards to the tax issue, and you made some reference as to an equitable division with each doing their taxes with 0, 1, or 2 dependent on, or claiming none of the children or all the children and seeing who gets the most equitable benefit. I guess the clarity that I'm looking for, and with previous counsel for Ms. Maselli that I had talked to, was that the actual order of the court? Was it a thought? I guess
that's the order. That's going to be the order. I mean, both parties should be doing their taxes where the maximum benefit is gained. And then it should be equitably divided between the parties. And how equitable that is sort of depends on the facts and circumstances of each case. And I sort of gave some examples, but those were just examples. And but you know, basically, as far as the order goes, is that it's pretty simple to state that the taxes should be done in such a way as to maximize any tax benefits to the parties, and any refund should be equitably divided. And then I guess we have the discussion, dispute then later on as to what is equitable. How much is it and what's equitable in it?
Okay. That's really the only reason I called the status conference, Your Honor, was to get clarity so I can get this order entered. So the taxes should be done in such a way that is equitable to both parties, and
the major thought is to maximize the tax benefits of both parties, and then it should be equitable to it. I mean, a simple example would be is if one party files and they have to pay $4,000 without any dependents, and the other party files and gets $10,000 back in benefits, then And if it's figured out the opposite way and it's not as much as a refund going on, well, then the $6,000 benefit really should be, you should maximize that. Maybe the 4,000 should be paid out of the refund of 10,000, and maybe then the 10,000, this remaining 6 should be equitably divided. But each case is going to depend on the facts of that case. And it's hard for the court to tell, but the whole idea is maximize the benefit through the government. And that could also mean that both parties owe money to the government, because I have no idea of knowing which situation arises. Most people get refunds, but there's plenty of people out there that pay at the end of the year. And this could be a situation where both parties pay. And so we try to maximize it so that the reduction in the amount of paid is the lowest possible.
Okay. So I'll just write it so that it I guess in more of a generic, so that the taxes should be done in such a way that'll maximize the tax benefit to each party, and the refund shall be equitably divided.
Or the benefits equitably divided, because I don't know if both parties pay in at the end of the year. Let's try to reduce the amount that they have to pay in.
Okay.
And equitably divide that part.
So the benefits shall be
it could be any ways, there's so many factual situations out there. I have no idea what's going on. The whole idea is to maximize the benefit for both parties.
Okay.
All right.
That's all that provides clarity to me on the bench's opinion.
Ms. Maselli, any questions?
No, sir.
All right. Mr. Summers, any questions?
No, sir.
All right. We're all set. We're in recess.
Thank you.
All right. All right, 55th Circuit Court is now in session. The Honorable Roy P. Meek presiding.
You may be seated. In the case of Laura Cisco, personal representative of the state of Rebecca Nicole versus Claire Upco LLC, doing business as Metalodge of Claire. That is case 19-900-237-NH. And calling the case of Laura Cisco, personal representative of the state of Rebecca Nicole versus Claire Upco LLC, doing business as Metalodge of Claire, Abood Solpidi, Corinne Howdyshell, Mid-Michigan Physicians Group, Mid-Michigan Visiting Nursing Association, and Mid-Michigan Home Care Midland. Counsel, identify for the record, please.
Good afternoon, Your Honor. Greg Wicks appearing on behalf of the plaintiff.
Steve Cholas on behalf of Metalodge of Claire.
Carol Carlson on behalf of Mid-Michigan Physician Group, Dr. Salipi and Ms. Howdyshell. Good afternoon.
You can come up to the table if you want.
I just said I'd farther away if you throw anything, like a gavel. Fair enough? Thank
I've
you.
been on the bench 14 years. I've never used a gavel.
Good to know. I feel safe.
All right. We're here today for the opinion based on the motion to compel arbitration in these two cases. Court heard the arguments, read the briefs. Court is going to deny the motion to arbitrate, basically for the reasons the plaintiff's response. Basically, I think, I know we want parties to work together to try to solve things, but there is a limit on how much time can go by when a case is started and when they ask for arbitration. And I have no idea what that time length is, but in this court's opinion, the time length that went on basically was a waiver of the motion to compel. And it's it's an odd thing here that we want parties to work together, but then again, motions to arbitrate are valid issues. And so really, I think the issue comes down to what's been put in the plaintiff's response. You know, I think the waiver of the right comes through in this case. So the court's going to deny the motion. And, I know it's not an issue legally as to whether or not there's a waiver of the right to arbitrate, but it doesn't make a whole lot of sense to arbitrate one part of the case and still have that party liable in the other part of the case because it's the respondent superior. So I know it's not a valid point to make in denying the motion, but just want to point that out. So plaintiff will draft up an order. Court will sign it. Is there anything else we need to discuss? I don't know if there's any dates set for any hearings or status or trial or anything like that. But I'll tell you this, we're in phase 1. We can't have a trial until we get back into phase 2. And we're not having a trial in May or June because I'm not calling in jurors. So I don't know where we stand with this case on the docket. I haven't looked. Anything from any party?
No, sir, Your Honor.
No, Your Honor.
Nothing, Your Honor. Thank you very much.
All right, thank you. We are in recess.